All right, welcome everyone. Welcome to the new time. Happy Monday. My name is Rilus Dana. Today I got some exciting topics. So we moved the stream from Fridays to Monday. Hopefully you guys are more rested, refreshed, and we're going to be talking about some fun stuff today, some tax stuff. Let me share my screen. So we'll give credit the intro music. That was a Wave Odyssey by Akira the Dawn. I had on for the start music. I still don't know how to do a timer yet. I'm working on that. Here's the presentation we'll get into today. So before we get into it though, welcome everyone to the stream. If you have any questions or comments, go ahead and leave a comment below. Comment your questions, anything that you'd like to see me discuss in the future. The best place to leave those comments is on the Mott Legal YouTube page. I can see the comments there, and I'm broadcasting from YouTube, and I shared it other places in Facebook. I don't know if as many people see it this way, but I think the sound sounds better this way, so I'm doing it this way. The other software that I was using, it allows me to see all the comments in one place, but I don't think the sound was as good. So go in this direction. Okay, so let me share my screen again. What do you guys think about those embarrassing thumbnails? Is that what you have to do to be a YouTuber these days? So today's video, the topic is we're going to get into an advanced married trust, what might be called a Clayton QTIPable trust, Clayton QTIP election. And I looked online. Most of the videos are pretty boring, so I'm going to go through some pictures and some diagrams to illustrate how this works. So hopefully this will be more interesting than the other ones. Go ahead and make sure you smash that like, leave a comment, and so we can get this video viewed more. I don't know if it's just the boring attorney videos that they get more views, if people aren't interested in stuff like this, but I think this is going to be more entertaining than just some guy at a desk talking. At least I'm sharing my screen and got some other stuff for you guys. Okay, here's a word from our sponsor, today's sponsor. Today's episode is sponsored by Dana & Associates. Dana & Associates is a law firm practicing in Arizona and California in probate and estate law. If you need help setting up your own plan, or if you need help administering the plan after the loss or disability of a loved one, we can help you with probate, estate planning, trust administration, and anything in between. Give us a call today to set up your free consultation, 480-924-4424, or visit our website at danalegalhelp.com. All right, today's sponsor, thank you. Recorded that, testing out my new little gadget here. Okay, let's get into it. First topic I want to talk about today: community property. What is community property? So here's some words first. This definition first I got from Investopedia.com. Defines community property as a U.S. state level legal distinction that designates a married individual's assets. So this is only for married people, and it's only in certain states like Arizona and California where I practice. Any income and any real personal property acquired by either spouse during a marriage are considered community property and thus belong to both partners of the marriage. Under community property, spouses own and owe everything equally, regardless of who earns or spends the income. Okay, here's how Arizona law defines it. It's pretty similar in California as well, the way the law defines it, but it's all property acquired by either husband or wife during the marriage is community property of the husband and wife, except for property that's acquired by gift, devise, or descent. Now, devise and descent, also fancy words for gift. It means receiving through a will, receiving personal property or real property through a will. And then the second part of the statute says acquired after service of a petition for dissolution of marriage. So that means the marriage is over. So it's got to be, so if it's acquired during the marriage and it's not a gift, then it's going to be community property. Okay, so here's our hero, Mr. Estate, star of our videos. He's got a bank account and a house, which is it's his separate property, and he meets the lovely Mrs. Estate. She also has a bank account and a house, or she's got a bank account and an IRA in her name, which is her separate property. So they meet, and then they end up getting engaged and married. Boom, ring on the finger, community is created. So another way I explain community property, I say once you're married, you no longer exist. Everything earned during the marriage belongs to the community. So income from the job, let's look at Mr. Estate's earnings, his earnings first. So he transfers things to his separate bank account. Is that his separate property? No, it's not. It's not a separate property. He doesn't exist anymore. When he earned that income for his job, that was earned by the community. So his separate account is now tainted, I would say. Even though it's just in his name, the community has an interest because the monies earned from his job are community property. So by default, when you're married in one of these community property states, everything by default is community property. If you want to show that something is separate property, you have the burden of proof to show that it was your separate property, that it was something that you had before the marriage or you received it by a gift. Let's look at Mrs. Estate. So she's got a job too. What about her income? She puts it in her IRA. So her IRA, the community now has an interest. It's still titled in her name, but she no longer exists. When she earns, when she goes to work, that's the community going to work. So that's same thing over there. So the community has an interest in her IRA for the portion that is earned during the time of the marriage. So he sells his house. They buy a house together in both of their names. They open up a house or a joint bank account. And then what about inheritances? This is one of the most common examples that I see. So Mr. Estate, his parents pass away, and he's the beneficiary of a trust. So if he receives money from that trust and he deposits to his joint community property bank account, well, that just became community property. He just lost the separate property treatment by transferring that into a joint trust. If he wants to keep his inheritance separate, he should open a new account in his name alone, so he can clearly trace and clearly show the origin of this money was from a gift, from an inheritance. So let's back that up. So inheritances, if they're deposited into a joint bank account, then that makes it community property. Or you have to show that it's not and try to get the toothpaste back in the tube, but it's going to be pretty difficult. So the better way to do it, instead of adding to a joint bank account, if you want to keep it your separate property, if that's your intention, open a separate account. Now that doesn't mean if that's a separate account that you have, but you're putting your paycheck in there from your earnings during from earnings during marriage, then that account is tainted. I would say open up a new clean account. It's very common that they'll come in to see me and they say, we ask to fill out some basic information about the assets that they own and how they're titled. And sometimes people will say, yeah, it's, that account is in my name. That's my separate property. And I ask some more details and realize that even though it's just in their name, it's the earnings from their job. And without a premarital agreement to opt out of these community property rules, they are in effect. So, okay. So community property is all property acquired during the marriage except for gifts. All right, next concept, and all of these things are leading up to that, what I call the Clayton QTIP trust, the advanced estate planning technique. Now let's talk about some of the tax basics. So you got your three major tax systems. Income tax, I think we're all probably the most familiar with this. If you receive income from your job, Uncle Sam gets his share and you get your share. Now it's up to the person that's working to file an income tax return to report that income. So they have the burden of filing for income taxes. Gift tax. So let's say Mr. Estate's dad here wants to make a gift to him. He transfers whatever it is to him. If a gift tax return is required, it's up to the giver to file that gift tax return. An estate tax return, so his dad passes away. If money is received from his estate or from his trust, then an estate tax may apply. So those are the three different tax systems. You got the income tax, the gift tax, and the estate tax. The gift and estate tax work together. Okay, the estate tax return, it's on the estate to file that return. Okay, let's talk about annual exclusion and exemption. So these are concepts related to the estate and gift tax. Annual exclusion, you may be familiar with this. For years, it was around $10,000. Now it's $15,000 in 2021. What this means is that a person can make a gift of $15,000 every year, and it's excluded from filing a gift tax return. So here's dad here. He wants to make a gift of $10,000. Since that's less than $15,000, there's no requirement to file a gift tax return. Okay, lifetime exemption. So lifetime exemption, also referred to as the estate tax exemption or the death tax exemption. What this means is how much money can be transferred until an estate tax applies. So that number is currently $10 million. It's adjusted for inflation. It's actually $11.7 million in 2021. But just to make the numbers easier, we're just going to focus on the $10 million. So let's say that Mr. Estate, he wants to make a gift of $1,015,000. And this is in a different year than that $10,000 gift. So he wants to make that gift. $15,000 of that will be annual exclusion, but he'll have to file a gift tax return to report the rest of that gift since it's larger than $15,000. Now the amount over the annual exclusion will be subtracted from his lifetime exemption. So in this case, $1 million gets subtracted from the lifetime exemption. All right, after he passes away, Mr. Estate Senior, his trust is worth $12 million, and he only has $9 million left of his exemption. So that means that $3 million of his estate would be subject to the estate tax. Of the $12 million, $9 million is exempted from the estate tax, and then the remainder amount, the amount over that, is subject to the estate tax. And then it's the estate tax, it's the estate that files a return to report that tax and to pay it from the estate before distributions are made to the beneficiaries. Okay, all right, isn't this fun? Some good stuff, fun stuff, I think, important stuff. So now let's talk about cost basis. This works together with the income tax. So what is cost basis? Cost basis is the original value of an asset for tax purposes. So if you buy a house, it's going to be the purchase price of the house plus the improvements. What is capital gain? It's the difference between the asset's cost basis and the current market value. And it's realized when the asset is sold. So cost basis, this is the price what the house is purchased for. If it later appreciates in value, then there would be a gain. But this gain is not realized until the house is sold. Carryover basis. What is carryover basis? So it's a method for determining the tax basis when an asset is transferred by gift. So Mr. Estate Senior, if he wants to give his house to his son's going to inherit his basis or receive his basis. The basis remains the same as the giver. So there's his basis, and there's the value of the house. So with carryover basis, it's passing the possible income tax burden of this gain to the receiver of the gift. Now, what is step up in basis? So this was the example if the house was given during estate senior, during his dad's lifetime. If the house was given to him, it would be carryover basis. Now, step up in basis, this is a readjustment of the value of an appreciated asset for tax purposes upon inheritance. The basis increases to the market value at the date of death. So if you passed away and then Mr. Estate received the house, his basis is going to be the same as the current market value as of the date of death. So if Mr. Estate sells the house right when he receives it, he's not going to have any capital gains. So there's not going to be income taxes due on the gains of this property. So it's important to talk about income taxes because the estate taxes, they don't affect as many people as income taxes do. All right, so now let's get into the advanced married trust. And I'm going to show you a little bit of the history in order to understand the current most modern estate planning type of trust. We got to look a little bit at the history to appreciate this. Okay, so Mr. and Mrs. Estate, they create a trust. They're the trustors of it, the trust creators. They're going to name the beneficiaries where things go after they're gone. That's what this hand is. The trustee who's going to be in charge. Now, it's going to be a dynasty trust. It means it's going to stay protected for the kids. Okay, they transfer their house, bank accounts in there, and Mr. Estate passes away. We're going to pick on him today. So the advanced trust, it's the same while they're both alive. It's going to be revocable while they're both alive. They're both in control. And it gets interesting when one of them passes away, when one of the trustors passes away. Okay, this scenario, Mr. Estate passed away first. So let's look at his wife's share first, Mrs. Estate. So her half of the assets, so her share of the community property, her half of the community property, and any separate property, if she has any, is going to go into what's called the A trust. These assets will get a step up in basis for the community property. Her separate property assets will not get a step up in basis, but assets that she holds as community property, her half of those will get a step up in basis. This is non-taxable, meaning not subject to the estate tax at this point, because it's her half, it's her part of the assets, and she's still alive. This is revocable. The trustee of this is going to be the surviving spouse, and she's also going to be the beneficiary. Now, after her death, after she passes away, it's going to be subject to the estate tax that a trust will. Her half of the assets will be subject to the estate tax after her death, but she has an exemption, and that exemption is currently $10 million. So that's how the A trust works. The most common trust that we're doing now for people is what we call a continuation trust, where it's basically just goes into one trust like this and then down to the children this way. Now, these assets, they do get a step up in basis again. So they're going to get another step up in basis. So for her half of the assets, they'll step up in basis upon the first death. She has full control over everything. After she passes away, they're subject to the estate tax, but she has her exemption, and then the assets will get a step up in basis. So that's going to save income taxes for the beneficiaries. Now, his half of the estate, so this is the old AB trust, and the way this works is the decedent's half of the trust, or the buried person. So you have the alive person over here, A. B is for buried person. We got the ghost of Mr. Estate over here. So their half, it's going to go into a trust, it's going to get a step up in basis. Everything's going to step up in basis. It's subject to the estate tax because he's already passed away. He has an estate. And then he has an exemption. Now, these AB trusts, if you've had a trust for a while, maybe you've had one of these at some point, and this was the only way to get 2 exemptions against the death tax. So that's why these were very popular. And another thing, the exemption was a lot lower. The exemption for years was around $1 million. In 2008, it was 1.5 million. So a lot more people had estate tax issues when the exemption was only 1.5 million. Currently at $10 million, the estate tax doesn't affect as many people. But yeah, this is the way that it was. You had to do an AB trust to get 2 exemptions against the death tax. This trust is irrevocable. It's considered the dead person's share. Now the trustee, sometimes they might have another person appointed to manage the assets in this B trust for the benefit of the spouse, or they can name the spouse as the beneficiary. I'm sorry, as the trustee, the one in charge. Now, sometimes we do these types of trusts for non-tax reasons as a way to control the assets of the deceased person. And sometimes we do these for the tax reasons, meaning we want just the extra exemptions and things like that. So in this case, we're going to have the surviving spouse be the trustee because we're interested in the tax reasons today. The beneficiary of the B trust is going to be the surviving spouse. Now, okay, so everything, we're going to use the exemption to fill up the B trust. So if things are taxable, subject to the estate tax, then the exemption is used. And then on the second death, whatever comes out of the B trust is not subject to the estate tax again. So $10 million could go into here when Mr. Estate passes away. Now, during Mrs. Estate's life, this could grow to $100 million. Whatever it grows to, it's not going to be subject to the estate tax again. However, carryover basis applies. So meaning these assets will not get another step up in basis in this B trust. They step up once on the first death. We use the exemption from the estate tax going in, and they're non-taxable coming out, but carryover basis applies. So for that growth, that period, and income tax may apply if the kids or the people that inherit these assets later sell them. Okay, C trust, also known as a QTIP trust. The way this worked traditionally was when you overflow a B trust. So when this exemption was much lower, this happened commonly. So today I'll use the example. Let's say this was a $30 million estate. So her half of the community property would be $15 million. His half would be $15 million, but the exemption's only $10 million. So the C trust, also known as a QTIP trust, is where the remainder would be held. So the amount over the exemption. So this QTIP election, it's a tax term, not the thing that cleans your ears. Marital deduction. What marital deduction means that if money is going to the spouse, they can wait to pay the estate taxes until later. So this trust is irrevocable. The beneficiary has to be the surviving spouse, and she has to be able to get all of the income out of there. The trustee, it could be someone else, or it could be the surviving spouse. Now, this is going to be taxable. So no estate taxes are owed funding the C trust or the QTIP trust because of this concept of marital deduction, meaning these assets are for the benefit of the spouse. So she can use them during her life, but they're going to be taxable when she passes away. Okay, so that's mainstream traditional estate planning. And when the game really changed was when this new concept was introduced. Oh, wait. So the C trust, let's talk about the step up in basis. So the assets that come out of the C trust, they're subject to the estate tax, but they get a step up in basis. So no one's paid estate tax on this amount in the seed trust yet, or it hasn't used an exemption. So it is subject to the estate tax, but everything in here in the seed trust gets another step up in basis. So if they had, Tesla stock in here for, $5, and then it's now worth $100 on the second death, it's going to save, that step up in basis is going to save the beneficiaries the income tax on the difference between the basis and the current value. Okay, portability. This was the game changer. So this concept was introduced and it was later made permanent. It was first in it wasn't in the Bush tax cuts. I think it was after that where they mentioned it, and it was set to expire. And it was later made permanent, but here's what it means. By portability, what we mean is that the exemption against the death tax is portable, even without a trust. It means that you no longer have to have a B trust to get a second exemption, that the surviving spouse can take that exemption from their partner and they can use it when they pass away. So now she's got her own exemption, and then she's got Mr. Estate's exemption. Portability. You have to file an estate tax return in order to claim that, but it gives the option to use two exemptions against the estate tax. For that reason, that's why most people, they end up getting just a regular, what we call a continuation trust, where it goes just straight into an A trust for the surviving spouse. And then when they pass away, if they did need a second exemption, they could get it. We have to decide on the first death whether they want to file that estate tax return and claim this second exemption, or if their estate is small enough where their own exemption will be able to shield them from the estate tax. So portability. So that really changed the game. So now that you no longer need this B trust to get that second exemption, planners started thinking. They said, you know what? It may be better to use portability and have assets, have the deceased share go inside of the C trust. Because the C trust, what we like about it is that everything in here will get another second step up in basis. So if the first spouse passes away, all the growth in the C trust, it's going to get a new step up in basis. However, it still has to clear the estate tax. It's subject to the estate tax, but so you get the step up in basis. All right. So before I get into the Clayton election, let's go into this. So it's taxable, but you have two exemptions to use. So whatever comes out of the C trust, subject to the estate tax, but it gets a second step up in basis. What this Clayton election is, we draft a trust where it says, how about if after the first death, the trustee can choose what type of tax treatment they want. They can choose whether it makes sense to have things in a C trust where it gets another step up in basis and we use the two exemptions against the estate tax, or is it a situation where we use the exemption to fund the B trust and get all of the growth free of estate tax, but have carryover basis. Now, really for the situation, I've crunched the numbers for some clients, and what it works out to, if you can really, if you have two full exemptions, so in today's world, that would be over 20 million, so a full 10 million to go into this B trust, and then all of that growth could come out free of estate tax. So that B trust might make more sense in those types of estates. It also depends on what the types of assets are in the trust, whether they're highly appreciating or if it's something that's not going to appreciate very fast. Now, for estates that are under the the 2 exemption amount, less than 20 million in today's current environment, a lot of times they're better having things in the C trust where it can get another step up in basis, and we have enough exemption from the portability to avoid the estate tax. That is a Clayton QTIP trust. Isn't that fun? Let me know what you think. I think this is probably the latest and most advanced estate planning tool. I'm bringing this up today as today's topic for a couple of reasons. One, I'm seeing more clients that are needing planning like this. And two, where do we think taxes are going in the future? Is the likelihood that the estate tax is going to go up in the future, that this exemption amount going to go up in the future, or probably down? There's been talks about maybe in the second year of the Biden administration where they may address this. And I know Bernie Sanders was targeting this as well. So we'll see if that results in lowering this exemption amount. So the proposals, I believe I heard Bernie Sanders was saying $3.5 million is where he'd want the exemption to go. I don't think they'll completely revamp this strategy and the system, but I think what's likely is they probably adjust the amount of this exemption. So if this goes down to $3.5 million, then a lot more people are going to need 2 exemptions, and then you want to start thinking about the type of tax treatment that you want. So hope you found this informative, enjoyable. I think it's interesting. Oh, let's get in. We got a little bit more before I wrap it up. Let's get into the dynasty trust. So one more point I want to cover is GST exemption, generation skipping tax, so the generation skipping transfer tax, to be more clear. So this is, you're limited in the amount that you can send into what we call a dynasty trust. So a dynasty trust is where it's going to pass estate tax free from generation to generation. So the generation skipping, you're skipping a layer of the estate taxes. So that the GST exemption is currently $10 million. So that means with an A trust or continuation trust, that's 1 GST exemption to fund the dynasty trust. Now, if the assets are larger than that GST exemption, let's say 15 million, so 10 million would go in this exempt trust, and then the excess goes into a non-exempt dynasty trust. It still gives the kids and the beneficiaries the same creditor protection, but it is subject to the estate tax when they pass away. Now with these B and C trusts, we can allocate GST exemption from there. So this gives us 2 GST exemptions to get more money into this exempt trust, more money that's going to pass tax-free to the grandkids and to the beneficiaries, to the future beneficiaries. So that's it for today. I hope you enjoyed today's broadcast. Leave a comment, any questions that you have about these topics. If you disagree with anything, I'd love to hear it. Future topics you'd like to hear, leave them in the comments as well. Take care, everyone. We'll see you at this new time of the broadcast. We're going to be going live on Mondays from now on at lunchtime instead of Fridays. I'm a little bit more fresh. I hope you guys are too, so we can cover more difficult topics. Thanks, everyone. Have a great week.